So the first step to examine anytime somebody is looking to either seal or expunge a criminal case is, does that person qualify to have the case sealed or expunged? So let's start with an expungement. If you're looking to expunge a case in Florida, generally the case would either have to have been dismissed outright, null prost, or a not guilty verdict found at trial. There are times where if a case has been sealed for 10 years, it can be expunged, but most expungements that are dealt with cases that are either dropped or null prost, or the case fizzled out at some point. To qualify, a person must not have any conviction in this or any other state in their entire life. I want to drive that home because this is the number one reason why I see cases where people are trying to seal or expunge a case fail, is because they don't qualify because they're either unaware of a case or they don't want to disclose a case. So again, if in 1992 you were adjudicated guilty of some trivial misdemeanor in the state of Pennsylvania, and then you're trying to expunge a case that was dropped here in Florida, that is going to be discovered in a background check, and you are going to be denied the ability to expunge a case. So again, if you've been adjudicated guilty of any charge in your past, you may not expunge a new case unless there are other statutory bases to do so, which you will also find on this website. Additionally, you can only expunge one case one time in Florida. So if you've previously expunged or sealed a case, that was the one time you were able to do it, and you cannot do it again unless there is a statutory provision to do so. When it comes to sealing cases, this is usually reserved for cases where adjudication is withheld. So when a court wants to sanction you in Florida, they can adjudicate you guilty and give you whatever sanctions, jail, probation, fines, court costs, etc. But if you're adjudicated guilty, that means you are convicted of the charge. That is for life. It does not matter, again, if it's some super serious felony or a trivial misdemeanor. If you are adjudicated guilty by a court in Florida on a criminal charge, that is on your record forever. Anybody out there saying, well, it's been more than 10 years, it falls off after 5, none of that is accurate. You can have as many withholds of adjudication as you like on multiple cases, and each case individually is available to be sealed, provided there aren't other reasons for it not to qualify, but you can only do it to one case. There are exceptions where there are multiple case numbers that are associated with the same case or controversy where they could all be sealed, but it is discretionary by the court. For example, let's say you get arrested for a misdemeanor DUI. You're arrested, you're taken to jail, your car is impounded. A day later, the police doing an inventory search of the vehicle discover narcotics, and they generate a new case number charging you with felony drug possession. If that ends up withheld and the DUI is reduced to a lesser charge, or let's say you go to trial and beat that and it otherwise qualifies, you may be able to seal both of the cases because they're arising from the same arrest or the same case or controversy. It's important to talk to a lawyer and be honest up front about your entire life circumstance and how the case resolved and any other criminal run-in you've had in this or any other state, because without disclosing that information, it will be difficult to tell accurately whether or not you actually qualify to have the case sealed or expunged. Do talk to an attorney about this, and if you have any questions, you can certainly contact my office for a consultation regarding this matter.